Her dog bit once. Then the landlord sued her for everything: a single dog bite, a single missing page, and a lawsuit that nearly cost one woman everything she owned. When the tenant moved into the ground floor apartment on Callaway Street in the spring, she brought 3 things with her: a secondhand couch, 12 boxes of books, and a 70-pound Labrador mix named after a jazz musician the landlord had never heard of. The landlord, a retired school teacher who had owned the duplex for 19 years, said she didn't mind the dog. She had signed a pet addendum to the lease. She had collected a $500 pet deposit, and for 11 months, the arrangement worked fine. Then came the afternoon in late February when a man walking past the property stepped through the side gate, left unlatched by a delivery driver, and the dog, startled and territorial, bit him on the forearm. The wound required 14 stitches, a course of antibiotics, and 3 weeks away from his job as a line cook. When the stranger filed suit, he named both the tenant and the landlord as defendants. He was seeking $47,500 in compensatory damages for medical bills, lost wages, and pain and suffering. The stranger's case was, on its surface, straightforward. He had done nothing wrong. He had not provoked the animal. He had not entered the property with permission. He had simply cut through what he believed was a shared access corridor, as neighbors had apparently done for years. His medical records were entered into evidence. His employer submitted a wage verification confirming he had missed 22 days of work at $9.40 an hour. His attorney argued that the landlord, as property owner, bore responsibility for maintaining a secure premises. The gate, they claimed, had a faulty latch that both the landlord and tenant knew about. There were text messages, 3 of them, in which the tenant had flagged the latch issue to the landlord over the prior 6 weeks. The landlord had never responded to a single one. The landlord did not dispute receiving the messages, but her attorney argued that responsibility fell squarely on the tenant under the terms of the lease. She had signed a document, her attorney insisted, that made her solely liable for any damage or injury caused by her pet. The landlord had done her due diligence. She had collected the deposit, secured the agreement, and acted in good faith. The problem was that when the defense attempted to enter the signed pet addendum into evidence, only one of its 2 pages could be produced. Page 1 outlined the pet policy. Page 2, the critical page containing the liability clause, was missing. The landlord could not locate her copy. The tenant claimed she had never received a second page at all. The case teetered. Without that clause, the landlord's entire defense collapsed into hearsay. The judge had grown visibly skeptical. Then, on the morning of the 3rd day, the landlord's retired accountant, who had helped her organize property documents during a 2021 tax review, arrived at the courthouse carrying a manila folder. Inside was a scanned copy of the complete 2-page addendum, uploaded to a shared drive during that review and never deleted. Page 2 was intact, and at the bottom, in blue ink, was the tenant's signature. The scanned document was authenticated by a digital forensics consultant. The metadata confirmed it had been uploaded 14 months before the lawsuit was filed, long before anyone had any reason to fabricate it. The judge allowed it into evidence over the plaintiff's objection. The verdict came after 4 hours of deliberation. The judge found the landlord not liable. The faulty gate latch, while a legitimate concern, had been made the tenant's responsibility under the addendum she had signed. The tenant was found liable for the full $47,500. The plaintiff received his judgment. The landlord walked out of the courtroom with her property and her savings intact, but the aftermath was not clean. The tenant, who had worked as a graduate research assistant, did not have $47,500. She entered a structured payment plan. She surrendered the pet deposit. She and the landlord, who had once waved to each other in the driveway, have not spoken since. The dog was rehomed with a family member out of state, and the stranger, who received his money in installments, told a local reporter he had never wanted it to go this far, that he had simply wanted his medical bills covered and a little dignity. Somewhere in a filing cabinet or a forgotten cloud folder, there is almost certainly a document that could change your life, or someone else's. The question this case leaves behind is a quiet one. If that second page had never been found, and the landlord had paid the full judgment for a lease clause she had written herself, would that have been justice, or just the law?